Good afternoon. Welcome to another edition of Legal Access. We get together each and every Thursday at this time to give you access to different aspects of the law. Today we're going to be talking about real estate law. So if you have any real estate law questions, today is the day to get those in. Here on the panel to answer those questions for you, to my left is Ken Corbett. Hi Ken, how you doing?
Good afternoon.
And we'll go all down the line here, but what's your firm name and what all do you work with besides real estate or in addition to real estate?
Corbett Law is the name of my firm, and primarily transactional law, commercial and residential real estate, but always as part of that there's usually some estates involved or some simple business organization, that type of stuff. Also
joining us to your left is Juliet Casper. Hey Juliet, what's your firm and what else do you work with too?
Good to be here, Dave, and my firm is Roy and Casper, and we handle transactional work, residential, commercial real estate, wills, and probate. I do not go to court.
I do not blame you. And to your left, Sam Stathos. Hey Sam, how you doing today?
I'm doing well, Dave. Thank you.
What firm are you with and what do you all work with besides real estate?
So it's going to sound like an echo chamber. The name of my firm is Patrick and Stathis, and we handle real estate, commercial, residential. I personally handle business law matters, I call them, but they're transactional and corporate matters that arise from that.
And you guys are not realtors, but I'm sure the first question a lot of people ask you is about the market and how strong it is. I know 2 years ago, 3 years ago, anybody could sell a house pretty much just because everybody was looking, but I know that the markets have kind of cooled off, or at least it seemed that way. How does it seem for you guys?
Well, in our office, it's been a roller coaster over the last 6 months, basically. Up until the last 6 months, I'd say for 2.5, 3 years, we've just been, just slammed. And things have slowed, but then they pick up and they slow again. I guess a lot of it, as you know, depends on the election and the market and rates and the world. But Myrtle Beach still is a beautiful place to come, and there's still a lot of people that want to move here, and there are a lot of houses being built.
Right, that's for sure. Now, a lot is made, as you mentioned, rates. A lot of people will talk about, the Fed lowering rates and this and that. Does that have any real effect on the actual markets? I mean, do people pay attention to that and buy or not buy because of that?
Yes, they do pay attention to the interest rates. It may be the difference between the sales price of a house, what they're going to be able to purchase based on that interest rate. Also, with the rates coming down, it's given an opportunity for some folks to do some refinancing to get some equity out of their house. So that's a great thing too.
Sam, since we're talking about rates, I know insurance rates are something that everybody's talking about right now, especially with the hurricanes and the storms that are going on. We know that insurance rates have skyrocketed over the past couple of years. Is that keeping people away from being able to afford their homes?
We've seen it. We've seen a dramatic increase, in particular with condo associations, those that are particularly right along the ocean, where you have a significant increase in the insurance rate that requires then a special assessment by the board, by the homeowners association, and that's what causes each individual owner to reassess, am I able to pay for that special assessment? Because unfortunately, like everything, where insurance rates don't usually go down. And if they hit at a certain level, which they seem to have, then the question is, well, maybe I can sustain it for a year or two, but am I able to continuously do that? And we've had clients that have come in and said, I think I need to sell because I'm not in a position to keep this up. So it definitely has affected owners on what they're doing with their properties. In particular, where are they? Are they residents of that?
Right.
Whether it's a house or a condo, is it a second home, is it investment, is it a vacation, is it bringing in income? And so all of those factors and variables come into play in that analysis.
And you can imagine rates are going to go up for insurance.
Right.
There's no way that the insurance industry is going to underwrite the tragedies that have existed in Florida, Georgia, Tennessee, North Carolina, and now adding on Florida again. It's certainly going to be passed on to every insurance company is going to pass it on.
Now, as real estate attorneys and helping with closings and this and that, who chooses where you go to? I mean, is it the buyer, the seller, or realtor? Who chooses which one of you to go to finish everything up?
The realtor? By and large, I think most of our, other than repeat clients that we've serviced before, new clients tend to come at the behest of the real estate companies, agents, and they'll usually, by ethical rules, have to give 2 or 3 names out, and that's how most of my referrals come in.
We do get some referrals from banks, especially for refinances, equity lines, and maybe commercial work. The relationship that you have with your local bank and the bankers can bring business to your office as well.
Now, not a lot of good things came out of COVID, but one of the good things, it loosened laws a little bit as far as procedures, I guess I should say, as far as closings were concerned. Did you guys find that to be positive?
I think we all probably have experienced that. So Horry County and Georgetown County historically have been a bit of a redheaded stepchild in the state in terms of how we actually disperse money and when we disperse it. And customary was that we're not going to disperse any money to the seller and buyer. You don't take occupancy until that deed is physically recorded at the courthouse in Conway. With COVID, out of necessity, we've all, I believe, adopted something that was anathema to us before, which is that we're going to electronically file, and we have a thing called table funding. And we've, some people might say, come into the norm as opposed to what we traditionally did. But
right.
Realistically speaking, that has caused some efficiencies. I think we can have parties at the table. You're able to make sure you've got your documents from the seller and the buyer. You've got funding, whether it's from the bank, from your buyer. You have all of that. You're able to upload documents, electronically file with the county, and that everyone can agree that the closing is taking place. And those are rather far removed from prior COVID procedures, I would say.
Yeah, I reluctantly embrace the table funding.
And I don't.
Yeah. Oh, I don't like it, but it's market driven. A lot of realtors will, if they know you're not going to table fund, they may pick another firm that does. It's a little risk for it, and that is, there's an old statute called the race to the courthouse. And during the Civil War, the Southerners were selling property 3 and 4 and 5 times, and the first person that got to the courthouse was the rightful owner. And that's the same deal now under the COVID. If we sign everything, I give the seller money and the buyer the keys, and then I go to the courthouse and there's an issue, everyone's going to be looking to me. Well, you're the attorney, and I'm saying I'm not on retainer to fix those problems. So it does create a very minimal risk, but not enough to make me stop doing it. So we're doing table funding.
Do you want to add to that?
Well, I don't do it because I get it recorded the same day. So it's not a big deal for them to wait a couple hours to get keys rather than handing them out at the table. It just, I like my staff to go ahead and record, and we know it's done. And with the electronic recording and the registered deeds efficiencies that they've created there, thank goodness,
Yes.
you can do it all in the same day.
But Juliet, I want to take a selfie with my new keys. Come on.
Well, it really
Well,
becomes.
I don't really want the keys in my office. The realtor can give the keys out
Yeah, me
whenever
too.
they
I
want.
Our phone number is on the screen, 848-8080. Give us a call if you've got any questions as far as real estate law is concerned. We've got Jerry. Jerry's in North are Jerry, I don't know if any of are you guys licensed
I
in
am
North
licensed
Carolina?
in North Carolina, so I could give it a
All right, well,
whirl.
Jerry, what's your question for the panel here today? Jerry?
Second home here in, are you there?
Yes, we are. Go ahead.
Yeah, I own a second home here in Myrtle Beach. I live in western North Carolina in Burke County, a little town called Glen Alpin, North Carolina. If I would sell my second home, do I how much is the South Carolina tax? And if I rebuy down here, do I still have to claim all the capital gains?
So Jerry, if you are going to have a gain on the sale here and you're interested in buying another piece of property here, you may be able to do a 1031 exchange and avoid paying the capital gains now. I would recommend that you talk with your accountant so you can go ahead and know what your basis is in the property here and how, if you want to purchase another property, that 1031 exchange would work. But you are correct, at closing, out-of-state sellers will have to pay the tax to the South Carolina Department of Revenue at the time of closing, and it's just under 7%. It's like
Yeah.
6.54
Some adjustment. Yep.
or something.
That's right.
I think to go along with that, I've also understood that a second home is not able to be done. You can't complete a 1031 under a second home. It has to be like an investment. If it's your primary or second home, you may not be able to do the 1031, but check with your accountant. He may have depreciated because you had rented it at some time during the ownership, and you may be able to benefit from that. But like she said, every out-of-state resident, every out-of-state owner that sells property in South Carolina, unless they do a 1031, is subject to that tax, because the Department of Revenue in South Carolina doesn't have that same long arm that the IRS does. And if you take your money back to New York, South Carolina's going, well, I can't get to it, and they put the burden on the attorneys to collect it. So we have to act as the collection agency for the Department of Revenue on behalf of the buyer when the seller's the one obligated to pay it. But it's just part of what we do.
And Jerry's in Western North Carolina, so now might be a good time to have a second place in Myrtle Beach, away from that area. But hopefully you made it through okay as far as the storm's concerned, Jerry, and thanks for your phone call. Again, our phone number's on the screen, 848-8080. Give us a call. We're going to take a quick little break right now. As soon as we get back, we'll have more of your phone calls as we're talking about real estate law here today on Legal Access. Welcome back to Legal Access. Real estate law is our topic here today. If you want to give us a call and ask us a question, the phone number is on your screen, 843-848-8080. Call us today and we'll get you on the air and get those questions answered. Our panel to answer those questions for you, we have Ken Corbett, also Juliet Casper and Sam Stathos here to answer your questions. Let's go to Philadelphia. Jedidia is on the line with us here. Sorry about your fills, but what's your question for us here today? Jay, you're on the air. Go ahead.
Excuse me, I wanted to know how a deed restriction is enforced, and how a deed restriction for those people impacted by it, how they get an older deed restriction that's been on the deed since the 1930s to be enforced if a developer is trying to come in and act as if they're not, those deed restrictions don't apply.
Well, so number one, the deed restrictions themselves, and there are several ways to define this, but what you're describing, something from the 1930s, would be whoever owned a certain number of parcels, or a parcel, frankly, placed restrictions on that property. And in that document, probably not in this 1930s document based on my experience, there may be a mechanism for the person that placed on them, and we may call them the developer, the declarant, to enforce those. The issue then becomes, where do those rights of enforcement go after that party is no longer the owner of that property? Have they been assigned, conveyed to someone else? And that is a question mark about the enforceability of that type of a document. Now, it's in the public record. You cannot, short of finding, say, that person, their heir, a successor company, or somebody that retained those rights, to even make an effort to remove those. So those may be an issue of having to get title insurance over those types of restrictions. There are other restrictions where say in the last 25, 30 years here at the beach, where we have new subdivisions developed, you've got large tract builders. They will put covenants and conditions and restrictions on the property, and may have more current terms and conditions where you can identify how can those be either amended or removed. But generally speaking, my experience with an older restrictive covenant, especially a deed restriction, meaning it is part of a deed, are more complicated and more difficult to enforce. It doesn't mean that you can't do that, but something from the 1930s, which is almost a century ago, is less likely to be enforced, especially because over that time, the nature and the character of the neighborhood and the subdivision of probably properties has changed dramatically, and oftentimes it becomes unenforceable. But as a matter of public record, you're not getting it erased off of the records in Horry County unless you're somehow able to do that by virtue of that document or any successor documents.
Thanks for that phone call. Appreciate it. Our phone lines are open, 848-8080. Let's go to Georgetown now. Jerry's been hanging patiently. Hi, Jerry. Thanks for calling in today. What's your question?
Well, I wanted to know if somebody wanted to file a lien on your property, are you required to get legal notice or notice from the court, even though the lien claim may not be legitimate? In other words, if they go ahead and do that behind your back, then it's on you to legally go in and contest it and spend a whole lot of money.
Well, obviously, someone should get legal counsel before they put a lien against anyone else's property, because if it's an invalid lien, it could be a cloud on your title, and you could have damages against that person who improperly filed it. But if someone did file the lien against you, you personally should be served with that lien by either a private process server or the sheriff to state, this is what's been filed against you. You need to seek counsel to figure out whether you have a defense to it or whether you need to resolve it in some other way.
Jerry, hopefully that helps you out. I appreciate it. Sorry for the situation that you're in right now. Let's go to Murrells Inlet. We have Art on the line with us. Hi, Art. Thanks for calling in today. What is your question for our panel?
Hi, this is in regards of purchasing a property in an HOA. Is it required by law for the person buying in there to get the CCNR's architectural guidelines and any other paperwork that may be applicable to the HOA, get that with their documents? And who supplies that? Is the real estate agent, the lawyer, the management company of the HOA, or the HOA itself?
Well, typically, those are documents that any buyer should review before they sign a contract. And typically, those documents should be provided to you, if not by your realtor, then by the management company for the HOA. Many of these subdivisions now have their documents posted publicly on their websites, but it is imperative that you review it before you sign a contract, because once you've signed the contract, you're basically saying you know that there are restrictions and you're accepting them, and you're going to go ahead to closing.
One way to deal with that would be to put something in the contract. And if, let's say you ask your agent for those documents and she said, well, I can't get them and the closing is tomorrow, we need to move forward. The way to deal with that is to put some contingency in your contract that says you want to buy this property for $1 million, but before you close on it, you want the opportunity to review all those documents during a period of time leading up to the closing. So that would be another caveat in the way of requesting those prior to you purchasing, because as Juliet said, once you've closed, you've assumed all those details, obligations, responsibilities, and headaches that come along with being a member of an HOA.
And I know one of the few laws that have been passed in Columbia over the past couple of years as far as HOAs or home ownership is concerned is that the HOA restrictions have to be revealed to any new buyers before contracts are signed.
You know, the issue there, Dave, is that they're public record documents, so they're recording the rules and regulations, and my beef with that statute, if you will, is it's just a mechanism, in my opinion, of gathering data, and there is no mechanism of enforcing any grievance. It's just more for the General Assembly to gather that information, figure out, oh, because it's statistically, Horry County has the most grievances of HOAs of any in the state, and then we park that somewhere and don't do anything with that information. But one of the questions that the caller asked is it a law? There isn't any specific law that requires you to say, you realtor, you attorney, you provide this to me. Your contract, if you've executed the contract, will allow you a due diligence period, but like both Ken and Juliet just expressed, there are many pitfalls, and the best thing you can do, it's be proactive. Ask your realtor. If they can't get it for you, maybe talk to your attorney in advance of your closing date. We've had that happen with our clients, and we try to educate our sources of referral, which oftentimes are realtors, and say, hey, if you're showing in this particular neighborhood and you're doing a little more work there, we'll email you the documents. We have those in our file. We can send those in advance of you having those issues rear their heads at the 13th hour.
And one of the things that Sam just said you might have missed is that Horry County does lead the state in the number of complaints about HOAs in the entire state of South Carolina, according to the consumer protection people or whoever it is. So,
well, we obviously
have
most
complain,
have HOAs in any other county in the state, so that goes with it. Not to discount the fact that there are problems with
or the most
HOA
vocal people here potentially. So yeah. So Art, if you're complaining, you're not alone. That's all I have to say. So tell you what, we're got to run to another break here real quick. As soon as we get back, we'll take more of your phone calls. We're talking about real estate law. Our phone number is 848-8080. Give us a call. We'll get you here on the air on Legal Access. Welcome back. It's Legal Access. We're talking about real estate law. We have a few minutes left, probably about 7 or 8 minutes. If you want to get in under the wire here, give us a call. The phone number's on your screen, 843-848-8080. We'll get you on the air and get your questions about real estate law answered here today. And Juliet, you mentioned off the air a couple of times that you're surprised we haven't gotten any calls about the reassessments and the rates that are out there. Insurance. I mean, what are you hearing? What are you getting all these phones blowing up at your office about?
Well, the tax bills came out the first week of October, and so it usually creates a lot of phone calls at our office, especially when the taxes have greatly increased from the prior year. The funny thing that the way our tax office operates is they issue the taxes in the name of the person that owned it January 1, even though the tax bill gets sent out usually October 1. So that always causes confusion, and of course this is a reassessment year, so everybody on the beach is seeing an increase in their real estate taxes.
Well, I've seen that the confusion was, let's say I have a piece of property that's worth, on the last reassessment, $200,000, but over the last 5 years it's gone up to say $1 million. Well, my tax bill's not going to go up based on the million because there's a cap in South Carolina on 15% of that value can only be taxed after any quadrennial reassessment. But if the property sold during that period of time, then the year following the sale, it does go up based on the value from the last reassessment. So, but taxes didn't.
And some people discover that they forgot to apply for their primary resident tax rate. They get their bill and it's 3 times what they thought it was going to be, and it's because they didn't file the paperwork with the tax office that they needed to get the discount.
You know, up until the last year and a half, I always sort of dogged the county because they were behind and they weren't really adept at taking care of that. But I applaud the county now. They've done a great job of identifying these issues to improve their systems and working with the taxpayers, you know, all 70,000 new of you that have moved in the last couple of years. So they've really done a good job of streamlining.
Now, also, there's a few other questions that are out there that are making a lot of news as far as real estate is concerned. Squatters. I mean, do we have any laws in South Carolina to keep squatters out of homes?
A squatter is a trespasser.
That's right.
That is. And so there's a civil and a criminal element there, literally 2 definitions. One of the things that, though, I will say it's happening is that we've seen here along the coast, and I'm aware of something that's occurred in the upstate where you have someone perpetrating that they own property and then go forward and try to list it and then successfully have sold it. And unfortunately, the unknowing end buyer, it's determined then that the wrong has happened and that you had a bad actor, a criminal. And so I think that most firms and we, when I say we, a lawyer seemed to be a point at a closing table of handling many different issues, one of which I never thought would be verifying the identity of the person who you believe to be your client.
That's right.
It's remarkable to say that, but with the amount of fraud, whether it's through trying to intercept wires or perpetrate a fraud on a buyer, realtors, lawyers, we're now in the business of also obtaining the proper software so we can validate the person that's hiring us is who they say they are when they go make that sale. And I believe that it's a minority, like a very slim possibility that could happen in this state, primarily because I think the place where it stops is you have a lawyer involved. And I think that that's an incredible value that we bring to the table, where we can, we have our to-do list, and sometimes, and intentionally, we should be held to that standard, but we also go above and beyond, I think, as a bar to protect our clients.
I know you're not to tax lawyers, but I mean to try to save people money as far as fees are concerned. Does somebody want to take a shot at the homestead exemption to maybe save some people some money?
Sure. After you've moved here and you've been here a year, you can file for that homestead exemption, which wipes out the first $50,000 of value on your tax bill. But more importantly than the homestead exemption is immediately file for that primary residence 4% application, because it can make a, it can make a big difference. It's not the difference in 4% and 6%, it's the difference of thousands of dollars if you fail to do it. And the county's been very helpful in letting people file for a year prior that they made a mistake. So I find that's the biggest issue related to homestead, not so much, but the
Right.
Primary residence tax break
Absolutely.
that we have.
All right, well, it's time for us to run. Appreciate all the phone calls and appreciate you watching here today. Want to thank our guest here today, Ken Corbett, Juliet Casper, Sam Stathos. I'm Dave Priest. We'll see you again next Thursday. Our topic's going to be personal injury right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this